the president from Article 155 to 156. So if you see the state executive, as we discussed in previous classes, in parliament, there will be executive with the uh, president of India, prime minister, and council of ministers, attorney general, etc. Here, the state executive also consists of same like union government. Here, president replaces with governor, chief minister, council of ministers, and advocate general of state. So governor as president heads the state government. So the provisions related to the state governments of the country are dealt with by the articles 153 to 167 of the Indian constitution. So if you see from 153 to 162, provisions are about governor. 163 and 164 is about council of ministers in the state executive. Article 165 says advocate general of the state. Advocate general means he is the legal advisor to the state government, like attorney general who is there in union government, like here in state executive. Article 165 says about the advocate general of the state, and article 166 and 167 says conduct of business of the government. If you see the appointment of the governor, article 153 says, according to the our constitution of India, that each state of the nation should have a governor. So he is the representative of the president of India, and he is the he will be appointed by the president. Under the 7th constitutional amendment, it was stated that there can be same governor for two different states at a time. So if you see the qualifications of the post of this governor, the qualification that one needs to be eligible for a governor position of a state or states are the if you see, he must be a citizen of the country, and they should be 35 years and above. As we discussed in previous classes, the age limit is for the post of president and governor is the same, so 35 years and above. Once the governor is selected, he shall be appointed to a state to where he belongs. So after the consult the chief minister of the state about where to be appointed. So the part 6th of the Indian constitution deals with this state executive system. So in 1979, the Supreme Court said that the office of the governor is not an employment under the central government. It is an independent constitutional office and is not under the control of or subordinate to the central government. So it is an independent constitutional office. So if we see the conditions of this governor's office, he should not be a member of either house of parliament or a house of a state legislature for this position of qualifications for this post of governor. If any such person is elected as governor, he is deemed to have vacated his seat in the house on the date which he enters upon the office of the governor. So he should not hold any office of profit, and he is entitled to such emoluments, allowances, and privileges as may be determined by the parliament. So his emoluments and allowance cannot be diminished by during his term of office. So if he appointed as the governor of two or more states, his salary and allowances payable to him are shared by the states in such proportion as determined by the president. So he enjoys personal immunity from legal liability for his official acts during his term of office. He is immune from any criminal proceedings and even in respect of his personal acts, he cannot be arrested or imprisoned. So, however, after giving 2 months notice, civil proceedings can be instituted against him during the his term of office in respect of his personal acts. So, the uh, oath of the office of this governor is administered by the Chief Justice of the concerned state's High Court. So, if we see the term of governor's office, he holds the office a term of 5 years. However, his term is subjected to the uh, pleasure of the President of India. So, the Constitution has not laid down any grounds for the removal of the position of this governor by the President of India. So, a governor can also hold office beyond his term until his successor assumes charge. So, if we see the powers and functions of the a governor of a state, so he has some executive powers, and also he is having some legislative powers, and also same like President of India, he is having all the powers within the state's jurisdiction. So if you see, he some of executive powers are exclusively allotted to the governor. So he is responsible for the appointment of the Advocate General of states and also determines their remuneration. So the major executive power is the chief ministers and other ministers of the states are appointed by the governor of the particular state. So he acts as the president's agent during the president's rule in the state, as we discussed. When there is incapability of the state government implementation during the Article 356 implementations, when president's rule imposed in a state, then the governor will act as a agent to the union government. So he is the representative to the union government and president of India. So in some cases, appointment and dismissal of the chief minister also in the hands of the governor. So some cases, the governor appoints chief minister, other ministers, advocate general, and chairman and members of the union public state public service commission and in the state. So after elections in the state, there is a convention to invite the largest party to form government in the state. So as we discussed, after the general elections held in the state, those who are getting majority in the house, majority of seats, which party got majority in the house, then the governor will invite to the party's leader to form the government in the state. So this convention has been floated many times at the whim of the governor. So some major executive powers are the governor is having this type of executive power in the state, and also every executive action taken by the state government is to be taken in his name. If we see every government order, every GO in the name of governor only, the state government will issue the government orders. So that is the important executive power which is allotted to the governor. So, and also he has legislative powers too. So governor may or may not send a bill to the state legislature concerning any bill that is pending in the state legislature. And also the state legislature is addressed by him in the first session of every year. As we discussed in the chapter Parliament, the President of India addressed by him in the first session of the Parliament after general elections. So same case applicable here in state legislature. So the governor will addressed in the first session of every year and also first session of after general elections. So then the governor appoints a person to preside over the session. The speaker and the deputy speaker of this legislative assembly are absent. So he has the authority to consult the election commission for the disqualification of members too. So he has also some financial powers. So the governor of state has similar financial powers to the same as president. So no money bill can be introduced in the state assembly without prior permission of the governor. As we discussed in the parliament case, the president yeah, has having the same power. So the constitution makes the duty of the governor to lay before the legislature a statement, estimated receipts and expenditure, that what we call it as budget. So that money bill or budget, the governor looks over the state budget being laid in the state legislature. So and also he makes advances to meet unforeseen expenditures, as the contingency fund of the state is under him. So every 5 years the state finance commission is constituted by him. So this all are belongs to the financial powers of the governor. So some of judicial powers also governor having. His recommendation is sought by the president before the appointment of the high court judges, and also in consultation with the state high court, the governor makes appointments, postings, and promotions of the district courts, district judges. So he also appoints persons to the judicial services with the consultation of the state high court and the state public service commission. If you see, some of the amendments made belong to the position of this governor. Some of the most comprehensive changes in the Indian constitution were brought in by seventh constitutional amendment back in the year 1956. So it was exclusively designed to implement the State Reorganization Act. So some of the changes that were brought forward by this amendment act are: it allotted two different states to have the same governor. It provided for maximum of 500 members directly elected by the territorial constituencies in the states, and a maximum of 20 members chosen from the union territories to the Lok Sabha. So if you see the governor's role, so if you see the role of the governor has some constitutional positions, differs from the president in the some cases. So while the constitution envisages the possibility of the governor acting at times in his discretion, no such possibility has been envisages of the for the president. So after 42nd Constitutional Amendment Act, ministerial advice was made binding on the president. So no such provision has made with the respect to governor so far. So the governor has constitutional discretions in the some cases, like he can dissolve the legislative assembly if the chief minister advises him to do following a vote of no confidence motion, following which it is up to the governor what he would like to do. So if a chief minister suggests to dissolve the legislative assembly, he can do that thing. So he can recommend the president about the failure of the constitutional machinery in the state. In this case, the parliament can review and impose Article 356 President's rule by the President of India. And also the governor can reserve a bill passed by the legislature for President assent some cases. So he can appoint anybody as chief minister if there is no political party with a clear-cut majority in the assembly. So what we call it as at that time, we will call it as coalition government. So if no party got clear majority, then governor called to the parties to make government. So at that time, two or more parties can merge and form government. So that will be a coalition government. And also he determines the amount payable by the government of Assam, Meghalaya, Tripura, and Mizoram to an autonomous tribal district council as royalty accruing from licenses for mineral exploration. So he can seek information from the chief minister with regard to the administrative and legislative matters of the state. And also he can refuse to sign to an ordinary bill passed by the state legislature. So these are the discretional, some discretional constitutional powers of the governor. And also major recommendations also there for this position of governor. The recommendations of the Sarkaria Commission and the Poonchi Commission report need to be examined closely to make proper amendments to the functions of the post of the governor. So some cases also there, the Supreme Court judgment which curtailed the power of the center to dismiss state governments arbitrary is commendable. Further, the removal of governor from office must entail impeachment proceedings in the state assembly. And also the governor's office should be apolitical. So there should be a panel involving the opposition, ruling party, civil society, and the judiciary in the selection process of governor. So governor should be appointed only after the consultation of the chief minister of the state where he will work. So these recommendations are also there, but according to the constitution only, the selection of the governor is going on. So if you see the council of ministers in the state, and also we are having syllabus about chief minister. So so once the legislative assembly elections of a particular state get over, the party that gets the largest majority in the house, then the leader of that party is appointed as chief minister of the state by the governor, as we discussed in the governor's executive powers. So Article 74 and 75 of the Indian Constitution deal with the Council of Ministers. So the Council of Ministers is headed by the Prime Minister of the country. So the salary and allowances of the Council of Ministers are decided by the Parliament. So now if we see the appointment of the Chief Minister, the particulars of the Chief Minister's appointment are not mentioned in the Indian Constitution. However, one thing that is absolute is that the Chief Minister of a state is appointed by the governor of that state. So the leader of the majority political party that gets the majority of the votes get to be appointed as the chief minister of the state. So in case no party gets majority, then the governor gets to use his discretion and appoint as a chief minister. So at that time, two or more parties can merge and form government. So if we see the oath of the chief minister, the chief minister takes an oath in the presence of the governor of the state before entering the office. So as mentioned, third schedule of the Constitution of India, so this oath of chief minister placed in the Constitution. So if you see the powers of the chief minister, being the leader of the ruling party in the state, the chief minister has been granted some powers by the Indian Constitution. So some of the powers of the chief ministers, like he is head of the Council of Ministers. So the chief minister is the head of the Council of Ministers. The ministers are appointed by the governor on the advice of the chief minister, and also he has a free hand in making a list of his colleagues, and the chief minister can reconstruct his ministry and when the need arises. So he can change portfolios. He can change portfolios with the governor. So he further has right to demand the resignation of any of the ministers under his. The chief minister also controls an agenda for the cabinet meeting. So he is the leader of cabinet too. Furthermore, he supervises and coordinates policies for several ministers and departments. So he is the link between the cabinet and the governor. So the decisions of the council of ministers are communicated to the governor by the chief minister only. So that's what we call as he is the mediator to the governor from his side. So he also needs to furnish any information relating to the administration of the state as the governor may call for. If governor asks something regarding to the administration or public policies, he has to furnish information to the governor's office. And also he is the leader of the house in the state. So being the leader of the house, he gets to make all the announcements concerning the new or amended policies, maintaining discipline of the meetings, maintaining discipline of the members of his party also comes under his hat. So adding to this, the chief minister can appoint a whip whose directive must be obeyed by all the legislatures. So the governor is a titular head or constitutional head. Also, at the same time, he is the agent of the center as the union government nominates the governor in each of the states. So whether it is appointing ministers or advising the president of the country, the governor has one of the most vital roles to play in the state government. So this is the powers of the state chief minister. So if we see the chief minister's duties majorly the communication between the governor regarding all the state decisions of the council of ministers, and also he has right to allot portfolios to his colleagues council of ministers. He can change, he can reconstruct his council of ministers as per his wish. So appointment of ministers are made by the governor after the consulting the chief ministers. So after 94th constitutional amendment of 2006 in freed Bihar from the obligation having a tribal welfare minister, as there is no scheduled areas in Bihar now, and the fraction of population of scheduled tribes is very small. So the same amendment also extended this provision to the newly found states like Chhattisgarh and Jharkhand. So here we have to remember that a minister who is not a member in the state legislature for any period of 6 months shall cease to be a minister. So usually the members of state legislature only appointed as ministers. So in some cases, the chief minister wants to appoint a person as a minister. He has to prove his membership within the 6 months of the period. So a minister who is a member of one house of the state legislature has the right to speak and take part in the proceedings of the other house, but he can vote only in the house which he is a member in particular house. So if we see the responsibilities of state council of ministers, the council of ministers works in the principle of collective responsibility, as we mentioned in the parliament chapter. So fundamental principle underlying by the working of the parliamentary system is this collective responsibility. So work as a team and swim or sink together. So article 164 says the acts of omission and commission. So in case it's no confidence motion against the council of ministers, all the ministers have to resign at that time. So cabinet decisions bind all cabinet ministers. even if they differed. So no legal responsibility, but they works under this council of collective responsibility principle. So in state government also, uh, uh, three categories of ministers. One is chief minister, ministers cabinet, minister of state. So cabinet means a smaller body called cabinet in the nucleus of the council of ministers. It consists of only the cabinet ministers major uh, portfolios. So if you see the council of ministers with the chief minister has the head to aid and advise the governor. So all the powers of the governor is made by the council of ministers and chief ministers. So the advice of the council of ministers only the governor act his powers. So if you see the role of the governor, the governor is the head of the state. So and also the powers and functions of the chief minister is implementing in the name of the governor. As we discussed, all the government orders and public policies will issue under the name of governor only. So as per the article 167 of the constitution of India, which states about the functions of the state minister, duties of chief minister as respects the furnishing information to the governor, etc. So it states that it is the duty of the chief minister to communicate to the governor of the states about the decisions taken by the council of ministers in relation to the administration of the state affairs and the legislation proposals. So to furnish the information to the governor's office which he wants related to the administration, the state and the proposals of for legislation. So it is also the duty of the chief minister as directed by the governor to ask the council of ministers to consider the decision of the minister whose decision has not been considered on matter on which that minister has given his opinion. So with regards to the state legislature, the chief minister can also advise the governor to prorogue or summon the session of the state legislature. So the legislative assembly can be dissolved anytime at the chief minister's recommendations to the governor. So all the government policies are announced by the chief minister on the floor of the house. So he is the chairman of some states planning board and also rotation serves as vice chairman of the concerned zonal council for the term of 1 year at a time. He is the chief spokesman of the state legislature. Is also a member of Prime Minister's Interstate Council and the governing council of Niti Aayog, and he is known as the political head of the services. So if we see the removal of the chief minister cannot be dismissed by the governor as long as he enjoys the majority support in the legislative assembly. So the other way out that he can be removed by the state legislative assembly if a no confidence motion is passed against him. So as one of the case N.T. Ramarao versus His Excellency the Governor of Andhra Pradesh, Hyderabad, and others, N.T. Ramarao was found to be guilty of misusing his position as chief minister, was removed from the office by then Governor Thakur Ramlal. So if we see the powers and functions of the Council of Ministers, one is formulation of policies. They are in charge for formulating the government's policies. The cabinet makes decisions on all key issues, including public health, disability, and unemployment benefits, plant disease control, water storage, land tenures and production, and the supply and distribution of goods. So the powers of the Council of Ministers, the executive powers must be used in a way that ensures that state laws are followed. So the Council of Ministers advises the governor on making rules and regulations regarding the working of the government for more efficient working. And also, the majority of the bills voted by the legislature are government bills drafted by the ministers. So the ministers introduce, explain, and defend them before the legislature. Each year before the start of the first session of the legislature, the cabinet prepares the governor's address in which it lays out its legislative agenda. And also, in certain situations, the union government has the authority to issue directives to the state governments. So states should use their executive power to guarantee that the laws passed by the parliament are followed. So they should not to do anything that might jeopardize the union's executive power. So the appointments, the governor appoints the advocate general, state public service commission members, the vice chancellors of the state universities, as well as members of the numerous boards and commissions. These all are done on the advice of the Council of Ministers. So the budgets are introduced introduced by the ministers in the state legislature, like the finance minister presents the state legislature with the state budget. And also, if we see the responsibilities of state Council of Ministers, as we discussed, the principle of collective responsibility, according to the Article 164, says Council of Ministers shall be collectively responsible to the Legislative Assembly. If a ministry which loses confidence in Legislative Assembly is obliged to resign. So the loss of confidence is expressed by rejecting any policy measure by passing a motion of no confidence. When a ministry loses the confidence of the Legislative Assembly, the whole of the ministry, entire ministry has to resign, including from the Legislative Council. They operate together as a team, and as we discussed, sink or swim as a unit. So it is the responsibility of Council of Ministers to support cabinet decisions both inside and outside the state legislature. A minister must resign if he disagrees with the cabinet decision. And also, individual responsibility of Council of Ministers will be there. According to the Article 164 says, the minister serves at the governor's leisure. According to the law, this means the governor can dismiss a minister if the council has the Legislative Assembly's confidence. In the event of disagreement or unhappiness with the minister's performance, the chief minister may ask him to quit or advise the governor to remove him. So the Council of Ministers are being appointed by the governor of the state with the advice of the chief minister and are being recommended and approved by the chief minister. So if we see the removal of these Council of Ministers, all the members of Council of Ministers of the state held the office on the pleasure of the governor of the state. So, but as already known that the governor exercises his power on the recommendations of the chief ministers only. So, if he want to change a portfolio from one ministry to one person to another person, he can suggest to the governor to change the portfolios to the ministers. So, as we mentioned, legislature plays an important role in the government work, such as passing the laws, giving consent to the treaties, keeping an eye on the executive branch, establishing government's budget, confirming executive appointments, impeaching and removing from office of the executive and judiciary, the members redressing the grievances of the constituencies. So so these all are the about the governor and chief minister, and also council of ministers. So if you see the position of the governor is required to function as an independent personality. As we discussed, he is the agent to the union government. He is representative to the president of India, and also he has some discretionary powers regarding states administration, and also uh, he has the power to assent and hold the bills passed by the state legislature. So these all are the about state executive. So if you see some recommendations are made by the some commissions also we have discussed. So according to the second administrative reforms commission, the interstate council should formulate guidelines on how governors should exercise discretionary power. According to the Rajmannar committee, emphasized that the governor of the state should not consider himself as an agent of the center, but place his role as the constitutional head of the state. According to the Sarkaria Commission, in its report, the commission recommended that Article 356 President's rule should only be used in very rare instances when it is impossible to prevent a breakdown of constitutional machinery within the state. So if we see in nowadays, there are more than 100 times where we are imposed this Article 356. So Venkatachalaya Commission also recommended allowing governors to complete their 5-year terms ordinarily. And also the central government should consult with the chief minister before removing them before the end of their term. So reimaging appointment procedure also, it would be appropriate to devise a committee comprising the prime minister, the home minister, the speaker of the Lok Sabha, and the chief minister of the state concerned to select the governor. So many suggestions, many recommendations has made by the different committees, but there is no implementation about these recommendations. So no clear distinction between the constitutional and statutory role. So the constitutional mandate to act on advice of Council of Ministers is not clearly distinguished from the statutory authority as Chancellor, resulting in many conflicts between the governor and the state government. For instance, there was a recent appointment of vice chancellor in a university by the Kerala governor by passing government nominations. So many cases, many clashes also there between the governor and chief ministers in recent times. So at that time, the government is neglecting governor's powers. So, but the constitution is there for implementing the governor's powers independently. So, misuse of discretionary powers also, we can observe that the discretionary powers of the governor has been misused in many instances. So, for instance, it has been argued by critics that the governor's recommendations for president's rule in the state has not always been based on objective material, but on political whim or fancy. So, for the position, the persons who are holding the position as governor is acting to the union government's wish. So no clear implementation of powers are there. So these all are controversies also there in implementing the powers and functions of the governor and the chief minister. So many critics also there regarding these issues. So this is the uh, concept of the state legislature. Is there any doubts regarding to the today's lesson? You may ask. Council of Ministry is responsible for Rajya Sabha also in case of Parliament. Today we are discussing about state legislature. Any doubts regarding today's lesson? If there is no doubts, I will conclude the session.
Thank you, sir.
Okay, thank you. Okay, all the best for your exams, upcoming exams. Write well.
Okay, sir.
Okay, thank you one and all. I am concluding
Thank
the
you so
session.
much.